Hello, good morning, everyone. Very nice to have you today for the second session on data privacy and transatlantic relationship. And today, I'm very delighted to introduce our first two panel members, Bruno Giancarelli, Head of Unit International Data Flows and Protection at the European Commission, and Jim Sullivan, Deputy Assistant Secretary for Services at the US Department of Commerce. Thank you very much to both of you. We know how busy you are with all the ongoing initiatives on data transfers, and we really appreciate you taking the time to update us on the latest development on transatlantic data transfers. And the least we can say about the past year is that it has been very rich and challenging in terms of data flows. Companies in all sectors increasingly rely on data transfers to do business, and it has been increased or even more with the current COVID-19 pandemic. And at the same time, we have experienced quite a disruption in transatlantic data transfers with the Schrems II ruling in July. And just to set the scene, let's go back in time for a second. And let's go back to July 16, when the ruling, the Schrems II ruling after the Court of Justice was published. And as you all know, the Privacy Shield, or the decision of the European Commission on the Privacy Shield, was invalidated at that point, but standard contractual clauses remained valid, but adding extra requirements on data exporters who want to transfer data outside of the EU to third countries. And since then, I think all organizations have been trying to deal with the question of data transfers, to understand how to interpret the ruling of the Court of Justice, and how to, in practice, continue the transfer of personal data to the United States and to other countries. And I think today we have the chance to have you to maybe tell us a little bit more about what you have been doing on the side of the European Commission, on the side of the Department of Commerce in the US, to help organizations continue transferring data. And just after the judgment was published on July 16, the Vice President Jourova insisted, and she said that in our globalized world of today, it's essential that we have a toolbox for international data transfers. And I know the European Commission has been working very hard on putting elements in that toolbox. And we have seen earlier this month the new draft standard contractual clauses being published. So I was wondering if you could tell us a bit more about those elements, about the toolbox, about what you have been working on since July to help organizations in their journey to the transfer of data. So if I can turn to Bruno Giancarelli to give us a kind of an update on what the Commission has been working on, that would be great.
Thank you very much, Elizabeth, and thank you very much for having me here. I can only concur with you that this has been a rich and interesting year on the front of privacy, on the front of data flows. So just to indeed, you have invited us to go back in time, a few months. After the judgment, we had three priorities. Number one, of course, comply with the judgment of our highest court by ensuring appropriate protection of data of our citizens when transferred abroad. Second, ensure that companies active in the European market can rely on transfer mechanisms to exchange data with their commercial partners, with their subsidiaries abroad, etc., etc. We fully recognize, and you have quoted Vice President Jourova, who I understand also spoke this morning at your event. You fully understand that we all recognize the importance of data transfers as an essential part of trade, as an essential part of cooperation between public authorities, as an essential part, I would say, to almost any human activity you can imagine, including social interaction, including the interaction we are having now. And of course, the pandemic, as you've said, has stressed even more the importance of data flows for instance, as our chat with you and Jim is showing, for the continuity of business activity, government activities, or the type of interaction we're having now. So equipping companies with data mechanism, with data transfer mechanism, and helping them comply with the requirements of the judgment that has been set. This is a very important second objective of our response, if you want, in the weeks, in the month following Schrems 2. Third aspect of our work, ensuring a consistent and coherent application of the judgment throughout the EU, and that you imagine, you can immediately see, involves working with the data protection authorities and with the European Data Protection Board. To these three objectives, I would say very quickly correspond to three essential work streams. The work on the SCCs, which is our almost immediate reaction and response. Of course, that work had to be carried out beyond and beside the judgment. There was a need to update SCCs, to align them with the GDPR, to make them also more adapted to the realities of the digital economy we know today. SCCs were developed sometime 1 decade or more ago. They were fragmented. You have different sets of SCCs. The package we have proposed, if I remember well, 2 weeks ago, is a significant modernization of our approach to SCCs. Single entry point, covering all forms of transfers, including transfers that were not covered by existing SCCs. Also, SCCs allowing more than 2 parties to use them, because we understand that today we're dealing with complex processing chains, which involve many actors. Possibilities also for new actors, new commercial partners to join SCCs later on during the business, the life cycle of a certain business operation. These SCCs are currently under consultation. We are having this week a number of virtual workshops. I must say that first, they are generally welcome, and second, we're receiving extremely helpful feedback from stakeholders, from the business community, from civil society. We already built our work on the SCCs on the feedback we had received throughout this year and last year, and I'm looking forward to the other stakeholder events, further stakeholder events we will have this week and next week. And then to come closer to what you said, these SCCs, and we of course waited for the judgment first to know whether the court would confirm the legality of SCCs, but also to try to reflect the requirements of the court judgment in the SCCs, and to give some more details about how we think it is possible to comply with the requirements of the judgment on 2 important elements of the judgment. First, that assessment that companies have to carry out on all the circumstances surrounding the judgment. You've seen that if you have looked at our SCCs, there's now a sort of checklist with a number of factors around the nature of the data, the type of business operation, business model, also the experience companies have with certain laws to which they are subject to, the volume of the transfers, etc. We very much believe that that assessment should be based on a key principle of the GDPR, which is the risk-based assessment. And the second aspect on which our SCCs are trying to give, yes, some more flesh to the judgment are the so-called additional supplementary safeguards that have to be put in place in case companies carrying out the assessment I've just mentioned would identify risks that then would need to be mitigated. You've seen that there we provide, for some example, from a toolbox, which looks at these issues from different angles. Of course, in the public discussion on Schrems 2, you hear a lot about technological solutions such as encryption, but there are many other ways, including through organizational solutions, legal solutions, to address those risks. So that's the first work stream. The second work stream is, of course, and I'm very happy to see Jim, it's early for him in the morning, the work we are doing with the US. You will have noticed immediately after the judgment a very constructive tone and engagement of both sides, which has been reflected in the joint statement issued by the two leaders, Commissioner Redress on the EU side, the Commissioner for Justice, and Secretary Ross, Commerce Secretary Ross. And on that basis, we have engaged in, I think, constructively in trying to map and define and discuss the various solutions that could be put in place to reinforce the transatlantic arrangement so that it can meet data flows arrangement, so that it can meet the requirements of the Schrems II judgment. Those are, of course, they would be for us, they are for the US, very complex and sensitive issues that concern the interplay between privacy and national security. That's never easy to tackle and to address. But we are absolutely convinced that this is an avenue to pursue, and we hope that we can indeed reach at some point and develop a new arrangement. You certainly, stakeholders expect us to deliver legal certainty. This is not just a new arrangement for the sake of a new arrangement, but we want, of course, stable and long-standing solutions for transatlantic data flows. That's why you cannot expect any shortcut or quick fix here. This is something that will need to be solid and that will need to be defendable legally and politically to be able to provide that solid solution that stakeholders expect, and I would say that they owe, and that we owe stakeholders. You have seen maybe, and that's, I think, an interesting sign and further confirmation of our engagement, that last week the European Commission has adopted a new communication on a joint communication between the European Commission and what we call the European External Action Service on a new EU-US agenda for global change, which looks at what are the important files on which we want to engage, and sometimes to re-engage and to intensify our work with our US partners, in particular looking at the future administration. And you've seen that there is an important chapter or section on digital issues. If you haven't done so, I invite you, everybody following this event, to have a look in particular at page 7, and you will see that facilitating data flows, free data flows across the Atlantic is a key objective of this paper. And I think the work that myself and Jim and our respective teams are doing can very significantly contribute to that. And last, but certainly not the least, third work stream, the work with the EDPB. And you've seen the EDPB, and I'm sure we'll discuss this in more detail, has issued issued guidance in the form of recommendations that are now under consultation until the end of this month. And there are different views and other opinions on this recommendation. We don't, and I'm saying this very clearly, we don't necessarily agree with everything, but I believe, and it is a draft, and we expect that the consultation will be a very rich one. But I think it has to be welcomed that the EDPB has fully taken has fully showed that it wanted to ensure that coherent and consistent interpretation and application of the judgment throughout the EU by issuing immediately after the judgment some Q&As, by issuing this recommendation, by creating a task force that deals with complaints that have been in the meantime lodged around the issue of Schrems II and transatlantic transfers. This is, I know the previous roundtable you had was about the GDPR. This is, of course, essential in terms of the GDPR governance system functioning, and really invite stakeholders to contribute and to this consultation on the recommendation. I think there's still a lot of knowledge, information, best practices that exist on the market and that could feed very usefully into that document. So this is what we have done and what we are doing in following the judgment. I understand, of course, that the judgment raises a lot of questions, concerns, anxieties. But there's also a bigger picture, and I will finish on that. I think actually today there's much more common ground to find between us and the US, and also at more international, multilateral level, solid solutions on data flows and on privacy. First, there's an increasing demand for standards in this area, for international standards in this area. Second, there is much more convergence. We have seen from Brazil to Japan, countries adopting or modernizing their privacy laws around a common concept. And third, in a number of common concepts, common safeguards, common enforcement and governance, common governance structures. I think that convergence is good, and we can build on that convergence to facilitate data flows, as we have done, for instance, with Japan by creating the world's biggest area of free and safe data flows. And third, there is at international level, in many international fora, I'm thinking G7, G20, OECD, the realization that like-minded countries should come together to work on this issue, define common standards, including when it comes to a sensitive and complex issues such as governance and access to data, which is first fully part of how we conceive privacy. Not only us, we are no longer alone on this, our US friends, our Japanese friends and others, and which is also a very distinctive feature between how like-minded partners, such as the US, such as Japan, such as others, see and view privacy compared to other systems in the world which might have a very different views on that. So to conclude, and sorry if I was a bit long, but you have asked what we're doing, so I wanted to show that actually we are doing something. But yes, these are difficult and uncertain times, but I think, as I said, that there are not today more elements to move forward and to bring to citizens the protection they expect, and to businesses the legal certainty they need to grow. Thank you.
Thank you very much, and it's very interesting that you finish up with this very positive notes on the work that has been done, but also the future and the progress. And I think of course for organizations, as you mentioned, legal certainty is really important. Having the new standards contractual clause, I think, as you mentioned, is a real progress to have modernized clauses that we'll be able to use. It remains very difficult for organizations to make this assessment as to, of course, the level of protection in a destination country. And I think, of course, as a Commission, you are very well aware of that, because when taking an adequacy decision, this is a bit the work that you have to do. So I think the difficulty with organizations are, and it's good that recommendations are coming from the EDPB that are aligned with the new standards contractual clauses. One question is maybe, when you think those are new standards contractual clauses will be already enforced, but maybe we can rediscuss that later, and maybe see the perspective from the US, and I'm turning to Jim Sullivan to see, because this judgment of the Court of Justice had, of course, the impact, and we have seen it from the point of view of the European companies, but it had a big impact as well on US companies who were certified under the Privacy Shield, and all of a sudden this decision of the European Commission on the Privacy Shield was no longer valid, but leaving those US companies with a question mark on what they should do from a US point of view and or from an EU point of view. And I think the question and the perspective of having a stable and permanent mechanism for the transfer of data to the US is very important for everyone. And if we can have Jim's views on this, and also on what the US has been doing on their side to help companies understanding the legal regime in the US with with this letter published in September containing the US Department of Commerce white paper to assist organizations in conducting this, what I call Schrems 2 assessment. I think that's really helpful. And it's interesting to see that there is still kind of a dichotomy between Europe and the US in terms of, for example, having to do this assessment, and from a US point of view, reviewing in this white paper that the US authorities are not interested in many of the data that are transferred from Europe to the US. But on the other side, the recommendations of the Commission saying that the assessment has to be done really on the law and the practice in the country, and has to be really objective and not subjective. I think it's interesting to see the point from the US, from the white paper, how really from the US side, you're working on facilitating those data transfers. So Jim, if I can ask you to update us on what you have been doing on your side in that respect.
Yeah, sure, I'd be happy to. Can you hear me all right, Elizabeth? Okay, great. Well, I'll start just by saying good morning and thanking you for the invitation to join the discussion as always. And Bruno, as ever, it's good to see your visage on the screen. I think you've both put it very well in terms of the fact that there really is no question that the Schrems 2 decision has created an exceptionally challenging situation for both sides. I think in rejecting the Commission's 2016 adequacy decision for Privacy Shield, the court unfortunately overrode what was a very hard-fought and well-crafted agreement that enjoyed widespread support from EU and US policymakers, from businesses and other groups. And at the same time, it's really unfortunately undercut the digital economy by putting at risk all global data transfers from Europe. And this, of course, in the middle of a pandemic when we're all increasingly relying on these transfers as more essential than ever. Schrems 2 has certainly generated enormous uncertainties for US companies in the $7.1 trillion transatlantic economy. Elizabeth, as you were alluding to, effective immediately on July 16th, we had the 5,400 or so Privacy Shield participants who found themselves unable to rely any longer on the framework as a lawful basis for transferring personal data from the EU to the United States. Just by way of reminder, I'm sure much of this audience already knows, well over 2/3 of the Privacy Shield participants at the time were small and medium-sized enterprises, meaning they had fewer than 500 employees. And many simply don't have the resources or the capacity to switch to more expensive and burdensome mechanisms like SECs or BCRs. And again, because neither the court nor the DPAs afforded any sort of enforcement grace period, these companies basically found themselves with three rather difficult options. They could switch to a more expensive mechanism. They could face potentially huge fines under GDPR, or they could withdraw from the EU market altogether, which was, of course, a very difficult situation. Now, beyond the Privacy Shield elements, and unfortunately, because of the court's ruling in the Privacy Shield context that US laws and practice relating to government access to data do not confer adequate protections to EU personal data, the use of those other mechanisms, SECs and BCRs, to transfer data is now in question as well. And I think, again, as you've both noted, since the ruling, that lack of legal clarity regarding transfers has prompted some companies to start looking at a variety of options, including data localization in Europe. And I think, the prospect of having to store and process all EU personal data in Europe is, again, another exceedingly expensive prospect, especially for SMEs, small and medium-sized enterprises. And it really poses a number of very significant technical problems for global business models of a lot of companies that operate in Europe. And I think in our increasingly digitized global economy, embracing data localization is going to set a very, very damaging precedent for other countries. I think it could imperil the free and open internet on which citizens and businesses on both sides of the Atlantic have come to rely so heavily. So all of that having been said, while we were, of course, deeply disappointed with the outcome, the United States does nevertheless respect the court's decision, and we remain committed to facilitating the free flow of data, while of course respecting individuals' right to privacy. And since the ruling, the Commerce Department has worked very closely with a number of other U.S. government agencies to consider how we can be most helpful to stakeholders that continue to rely on transatlantic data transfers. And to that end, as you alluded to, on September 28th, the U.S. government released the white paper to assist organizations in doing the assessments that the court required to determine whether or not EU-U.S. data transfers offer appropriate protection in accordance with the ruling. I'll summarize it because there was a lot of information, but the white paper includes a really wide-ranging amount of information about the extensive privacy protections that current U.S. law and practice provide relating to government access to data for national security purposes. And from our view, certainly it's ultimately up to the companies to make those case-by-case assessments that the court required. I think the information really can assist organizations in conducting those assessments, and we've gotten some overwhelmingly positive feedback on the white paper to date. I think, unfortunately, the recently released guidance that we've gotten from the EDPB does not seem to offer a very clear path for the use of the SECs for transfers for most firms. And I think that just underscores why the negotiation of a quote-unquote enhanced privacy shield is all the more important. I think when we think about what's going on with Privacy Shield, it's very important to remember that the court's ruling really was focused exclusively on government access to data. The court in no way questioned sort of the commercial elements of the framework. Those are not at issue. Those are not in question. And so with that in mind, as Bruno spoke to, we have been working with the Commission since well before the ruling and immediately after the ruling. He alluded to the August 10th joint statement from Secretary Ross and Commissioner Renders. But we have been working very closely over the past several months to negotiate targeted enhancements to Privacy Shield that really do two things. Obviously, we want to address the court's concerns. We want to make sure that we craft enhancements that will withstand future legal challenge. And we also have to make sure on our side that we preserve U.S. sovereignty and our national security responsibilities to our citizens and to our allies. So we have been working on an ongoing basis with the Commission. I think we're both committed to negotiating a privacy shield, an enhanced privacy shield as quickly as possible, again, to restore clarity and certainty with respect to transatlantic transfers. Another note I do think it's important to underscore is, just as the protections and redress benefits that were afforded by the Privacy Shield ombudsperson mechanism were made available to transfers pursuant to all EU-approved mechanisms, it's our expectation that any enhanced Privacy Shield would operate in the same way and therefore alleviate companies of these rather onerous case-by-case assessments that they now have to do of national security regimes. I think, excuse me, we have had very constructive 3.5 years with our 3 successful annual reviews. There has been an ongoing dialogue before, during, and after each of those reviews. And I think we should continue to build on those. Another note I just wanted to get in, there is a question, or I think sometimes some confusion that we hear from some, particularly in Europe, if the Commission's 2016 adequacy decision was invalidated, why is the FTC continuing to enforce Privacy Shield, and why is the Department of Commerce continuing to administer Privacy Shield? And I think, for us, the primary motivation is we want to ensure continuity while we negotiate these enhancements to Privacy Shield. And so we are continuing to process certifications and recertifications under the program. And obviously, FTC Chairperson Joseph Simons confirmed in August that they are continuing to hold companies to their Privacy Shield promises. And I think, that should send an important signal. Obviously, there are ongoing commitments under Privacy Shield, even though it is no longer a valid method or mechanism, I should say, for transatlantic transfers. Again, I hope our collaboration, which has been very constructive and positive to date with the Commission, will continue as we seek to develop durable solutions to ensure unimpeded transatlantic data flows. There are, as we've alluded to again, complicating factors, as there always are. We fully understand that because Schrems II is regarded as a constitutional judgment, it poses a number of legal and political constraints for everyone involved. I'm sure this audience can appreciate that there is skepticism among some in the United States about making additional unilateral concessions and entering into yet another arrangement that could potentially face even more legal challenges or greater demands for changes to U.S. law. And I think, again, I doubt there's much secret here, but that skepticism can sometimes be compounded by the fact that Europe has yet to apply anything close to the same level of scrutiny to data flows to authoritarian states, for example, that it does to the United States. So I'm going to cut myself off and truncate my remarks here because I think Bruno said it well when he wrapped up. I think at the end of the day, we certainly have more in common than I think we sometimes both care to admit. We're both democratic societies. We respect civil liberties and the rule of law. And despite our differing regulatory approaches on these issues, we do both share the same values with respect to privacy and data protection. And we were certainly encouraged by the Commission's proposal last week for a new EU-US agenda that calls for closer transatlantic cooperation on, among other things, facilitating the free flow of data and opposing the increasingly unbridled collection that we're seeing of personal data by authoritarian states again, to surveil, to manipulate, to control their own citizens and others around the world. And I think in the final analysis, I share Bruno's confidence that we will find our way together as we have so many times before. So thank you again for having me, and I look forward to a very interesting discussion.
Yeah, thank you so much for that. And I think it's really good to see the willingness on both sides to of course to comply with the judgments of the courts, but at the same time to allow the continuity in data transfers. And I think one point which is maybe a bit difficult for organizations is also the question of the timing, and knowing what they have to do. Thinking that the new standard contractual clauses might be enforced early 21, that companies will have 1 year, according to the draft, to replace their existing standard contractual clauses, not knowing exactly around the timing for an enhanced privacy shield. And Bruno, you mentioned at some point, but of course, it's I understand you cannot be more specific. But I think for companies trying and organizing themselves and having to renew all the data transfers might be difficult if they have no idea on the timing. So Bruno, if you want to comment on that, or happy to.
Yes, you asked first. I think we understand and we share the sense of urgency. That's why you've seen we immediately engage with the US and we have developed a new set of SCCs, standard contractual clauses, which let me stress the standard contractual clauses. Why did we focus on that? Because this is something we had to do, but because standard contractual clauses are the #1 most used transfer mechanism for transfers from the EU to third countries, and they are particularly useful and helpful for small and medium companies which are looking for sort of off-the-shelf instruments, as they might not always have all the necessary time, resources, legal expertise to engage in difficult and sophisticated operations. When do we expect to adopt the SCCs? Well, this is not something the Commission is completely in control of. As you may know, we are in Brussels. I am in Brussels, and Elizabeth, probably you also in Brussels. I don't know, but there are a specific decision-making process, and the one we thought now entering into the Brussels lingo. But the one that concerns the SCCs is the one that applies to the adoption of so-called implementing act. What does it involve? Proposal of the Commission, opinion of the European Data Protection Board, green light from representative of member states, and then final adoption of the Commission. We want to complete this process in the first 3 months of next year. So it's not tomorrow, but it's close enough in time. And then indeed, we then, the STCs, and this I'm sure will be discussed a lot in the consultation, provide for a transition period between, we recognize that, you know, it's not that you can change your contractual arrangement overnight. You might have many vendors, many business partners, etc. So we have proposed for 1 year transition period. With the US, I can speak on my behalf. This is a negotiation, and the negotiation on complex issues is not something that can be dealt with overnight either. But I think there is on both sides a sense of urgency. What you've seen in the communication of last week shows that this is a priority for us. And then, as I'm sure Jim can confirm, we expect to move quickly. And when I said at a certain point in time, I cannot, of course, know that point in time, but to reach an agreement on a number of solutions. But what will be fundamental for us is, of course, compliance with the court judgment. Jim has also said that, and I certainly welcome that, because this is key for what you are looking for, which is legal certainty. We have often questions about what should companies do in the meantime. And again, I understand those questions. Enforcers, DPAs also understand that question, that we are now in a period of uncertainty, where it might not always be easy to know what you should do, which tool you should you should use. Sorry, I think that in this interim situation, a first thing to do is to rely on the basic principle of the GDPR, which are accountability and risk-based approach. What does it mean in the term of transfer? In a certain sense, let's go back to the judgment. Why did the European Court of Justice confirm the legality of the STCs? Because the STCs had already a mechanism of assessment of the transfers, and that was, in a certain sense, inherent in the functioning of the STCs. So, what do you have to do in this interim period? Assess, map your transfers, know what data you are processing, where you're transferring it, under which safeguards, document that assessment, document that mapping. It's part of the basic accountability obligations, document the safeguards. And we see that on the market, many companies have developed what I referred to earlier as best practice. I think that mapping and documented mapping is essential, because if a regulator, if an enforcer would knock at your door, they would expect that understanding and that knowledge of your own processing and of your own transfers. They might disagree, they might ask you to add a certain type of safeguards, but having already done that assessment and having documented that assessment will be a much better basis for the type of dialogue one we have with regulator, with enforcer in this complex period. So that's both in terms of time and in terms of things one may want to do immediately. I think that's could be of interest to the audience.
Yeah, thank you very much. And maybe let me open the panel to and the discussion, this very interesting discussion, to our two other panel members. Iverna McGowan, who is director of the European Office of the Center for Democracy and Technology. Iverna, welcome to the panel. And Thomas Bouet, Director General Policy EMEA at BSA, the Software Alliance. Welcome to both of you. I think we have started a very, very interesting discussion. So I would like to bring you in the discussion, and from your point of view, maybe starting with Iverna. What is your feedback? What are your views, and what is your reaction to the current discussion?
Well, firstly, thank you so much for having me. I'm delighted to join you today. Obviously, the Center for Democracy and Technology is an advocacy that advocates in the public interest and looks at democracy and human rights in particular. So I think that's an important point to stress. And from our perspective, when we saw the European Court of Justice, we have offices in Washington and now an office in Europe, in Brussels as well. What we were welcoming in a way was that the European Court of Justice ruling was essentially a human rights ruling. There has been a long-term imperative for, you know, as my colleagues in Washington have advocated for as well, reform to US surveillance laws. And now we feel in a way that the European Court of Justice has done is on top of that made an economic incentive to look at these points. So we would really stress, but I'm very glad to see that the former speakers raised a really important point that we shouldn't look at this in isolation. We also need to think globally. The European Union has played a very important role globally, you know, leading the way in terms of looking at the international right to privacy as a human rights right, and with all the points that that has. And we need to be really mindful about how this plays out, indeed, for the implications in countries around the world where investigative journalists, human rights defenders, members of the opposition are under increasing pressure on how that data can be used or misused. So I think that's a really important point. Other speakers earlier in your conference today have talked about, yes, that GDPR is an extremely important piece of law. Unfortunately, its enforcement has really been lacking. And it's a slightly different point, but although it links into this as well, at the Centre for Democracy and Technology, we've been discussing a lot with the European Commission, Vice President Jourova, who I know you also spoke to earlier today, about the implication for democracies and the use of data by you know, social media platforms, etc. And in that conversation, again, it becomes clear about the importance of enforcement of GDPR. So not everything is rosy in Europe either. You know, that there's points to be made, and in that sense, as well as, of course, the, you know, just the fair look at saying, how do we, as Mr. Sullivan had said, look, really interrogate within Europe as well. Are we holding ourselves to the same standards within the European Union? So that, I guess, just to bring that broader point of how use of data can impact our democracies beyond even the commercial elements that have been discussed a bit more this morning. So obviously, as I had mentioned before, at the Centre for Democracy and Technology, and particularly through our advocacy in Washington, there was a couple of points that we have long time advocated for. On the topic of privacy generally, we have pushed a lot for federal level privacy law in the United States. We think that's an extremely important point. There's elements of it that touch on this. There's elements of it that would also help with the points we said about the use of personal data in democracy. But it's also a bigger point. The challenge was rightly raised about data localization. So there's a certain narrative that's saying that, you know, that the problem of data localization has to be solved by coming up with different arrangements and workarounds. Whereas we would argue is that if we had a stronger privacy baseline globally, that would itself facilitate, you know, to keep the global economy going and do that. So it's a bit of a shift in perspective, but one that we feel is very important, because we do see the challenges of data localization, but we'd argue that a common baseline on privacy would be the correct solution to that. And then in terms of the calls on the US side, CDT has long advocated to, you know, to prohibit upstream surveillance. As you'll know, been active in cases such as the Wikimedia versus NSA court case in the United States, limiting the purpose of US intelligence agencies to obtain personal data under Section 702, and ensure that anybody whose rights are violated intelligence surveillance have a right access to effective redress. And that's, what does access to its effective redress look like? And of course, we would argue the same in Europe as well. It's a very important point. And I'm really interested, perhaps in our follow-up, to hear from Mr. Sullivan about, on the point of redress in particular, what options are being looked at? Is that part of the equation? Do you think it's even politically feasible? That would be a really interesting point, just to hear feedback and your perspectives on that. Thanks so much.
Yeah, maybe we can go to that question and rediscuss surveillance laws and whether you think this judgment of the Court of Justice may have an impact on surveillance laws in the US, but also in Europe. But first, I would like to hear from Thomas Bouet his reaction on the what has been said so far, and giving another perspective, also maybe from the perspective from companies that are transferring data from the Software Alliance. What are your points and your takeaways of the discussion?
Yes, good afternoon, Elizabeth. Good afternoon, everyone. Thank you very much for having me, and it's great to be here. Before I start, maybe just a quick word about BSA and who we are and what we do. BSA is a global trade association representing the enterprise software industry. So our companies are software companies that provide services to other businesses of all size and all sectors, to governments, to manage their data processing activities. And we've said it. 2020 has been an extremely interesting and challenging year with regard to data and data flows. And there's a few things that come to mind and that have been said before. First, global pandemic. As of March, 80% of the world had to go and work offline, work from home, and rely on digital technologies. That has an impact. This is all possible due to data flows, and it concerns all companies, all sectors, all sizes, not just even the economy. It's just about society and all aspects of human activity. And in this regard, BSA, we launched earlier this year the Global Data Alliance, which is another alliance where we have companies from all sectors of the economy, from agriculture to airlines to manufacturing to others whose businesses rely on data flows, and ensuring that there's a proper data flow for their services in full respect of privacy law. And we were very much welcoming all these efforts, all these activities, and obviously we had the Schrems decision that was highly anticipated, that has cast dark shadows on the ability for data flows globally. BSA, we were an amicus curiae in the case in Schrems. We were also an amicus curiae in the challenge of the Privacy Shield. We are really working very hard to ensure that we have proper data flows around the world, because it goes about our ability to continue doing what we do. Now, I would like to say that the situation we're in today is not a new situation. We were here in 2015, and we probably will be there in a few more years, because today, all kinds of data transfer agreements are being challenged for a variety of reasons, and including very legitimate reasons. But finding solutions and ways forward is important. Now, from the discussion this morning, I'm an optimistic person by nature, and seeing the willingness of on the one side, the European Commission and the US government on the other, to try to find, how do we address the privacy shield situation? How do we create another mechanism that can, bring back this sort of balance between, EU-US data transfers, but more globally, how do we move forward on that? And that is a good thing. I think there's a lot of great work that's being done by Bruno and his team and Jim and his team. I think they've all said that trying to find ways forward is going to be important. We've been at BSA spending a lot of time trying to process the judgments. And Schrems trying to find what ways forward. Bruno was mentioning earlier the toolbox available to companies. I think for us, we're also looking at the toolbox in the SCCs. The court, has now imposed a number of things. I think one of the things that we've been focusing on very much at BSA is the toolbox for the safeguards. I think the courts, mentions that there needs to be contractual, organizational, and technical safeguards that we've been working on. We have put together our principles of what they would look like. They very much track the new draft SCCs that the Commission put forward a few weeks ago, and that is a good thing. I think there's a lot of like-mindedness in how we can move forward, and what are the things that can be done, by companies, by government, etc. But what I would like to maybe focus on now is a thing that's been said many times. I think the biggest issue at stake today is not so much the misuse or mismanagement of personal data by companies. I think there's some, and there's court cases and enforcement going on around the world, including in Europe. But what's key at stake here is trying to find what would be acceptable government access to data and national security practices. This is the biggest issue, the biggest thing at hand, and this is the thing that we as companies, as business organizations, cannot do. This needs to be a government-to-government discussion. Bruno mentioned earlier there is some work ongoing or some discussions happening at OECD level. This is great. These are things that we need to push and further, and we have all these efforts will have our full support, because like-minded, elected, democratic societies need to protect also their citizens. They have a duty to conduct national security, but what are the standards? What is acceptable, what is not acceptable in our democratic societies, and trying to maybe agree on a set of practices and best practices and principles for access to digital evidence and appropriate levels of independent judicial oversight are things that would be important. So that is in the long term. This is not going to be done overnight. This is a thing that we should all strive for. In the meantime, all the efforts that are ongoing within the Commission, in the US government, both sides working together to try to rebuild trust and data flows is an extremely important element, and we stand ready to continue working and engaging to make this a reality.
Thank you. Yeah, and I think I would like to go a little bit deeper on this central question and issue, which is around, on the one side, human rights, and the other side, access to data by government and public authorities and surveillance laws. Because I think that's, as you all mentioned, this is core to our issue today and to data transfers. And I think it's not just a question of looking at whether US surveillance laws are, but maybe to be broader than that, because we will have to look at this, and also to look at ourselves, to look at Europe, and maybe one aspect and one question for Jim in that respect. We have been talking about the enforcement. We have been talking about right of redress. What do you see? What the perspective are maybe in the US in that aspect? And do you think that this judgment and the current context might have an impact on surveillance laws in the US? And another question that is related is, we have been mentioning federal data privacy laws. Do you see any chance, and maybe is there a very difficult question or even impossible question, but do you see a federal, like in Europe, what we call omnibus privacy laws for the US, or do you see each state having its own like CCPA like law?
When I start with the privacy question first, certainly I think everyone is aware there's a very robust debate ongoing in the United States right now on exactly that issue, and we're seeing a number of states, I think I've lost track, I know it's over 30, I think at this point, a number of states that are actively either they've already implemented some sort of privacy legislation or actively considering it. In terms of this question, will there be a federal privacy law that's roughly comparable, that's something akin to GDPR, an omnibus law? I don't think I can speculate as to if that might happen or when that might happen or what that might look like. There have been attempts in the past, and I'm sure they will continue in the future. And prognosticating on that is probably something I'm just not in a position to do. I'm hard pressed to see how that though might directly address what we're dealing with in Schrems 2. I mean, obviously Schrems 2 again focused on these issues related to government access to data, and I guess pivoting to your point on surveillance laws and Averna's point, I will say just at a high level, I think especially since the U.S. surveillance reforms since around 2015, from our position, folks like to call GDPR the gold standard when it comes to privacy. I do think when it comes to these issues of government access to data, in terms of everything the U.S. has done in the last couple of years, the U.S. is quite frankly the gold standard when it comes to protections and transparency around government access to data for national security purposes. And I think in many ways, what we have done in that space, our protections are more robust than almost all other countries, including many member states in Europe. But to Averna's point, if you boil the case ruling in Schrems 2 down to the 2 points on Privacy Shield. It came down, of course, to proportionality or the scope of collection and redress. On redress, I don't think it'd be appropriate for me to get into too much detail about what Bruno's team and my team were talking about in the negotiations on that particular issue. But I think, there are some points that have been made out there. If you look, for example, at the essential guarantees document that was put forth by the EDPB, I think it is helpful that they noted, for example, that redress not necessarily has to be judicial in nature. And so I think that opens up some opportunity for us to reach some sort of compromise or negotiate something with that in mind. I think, again, going back to the broader theme, the conversation, in my experience, really is starting to shift. Certainly, the United States and Europe take different regulatory approaches to these issues. From my point of view, for whatever it's worth, personally, I do think the United States has the oldest and arguably the most robust privacy regime in the world. And I know with GDPR, you have what is arguably the most progressive and comprehensive privacy regime in the world. Again, we do share the same values. And so I do think there has been a shift, a growing recognition of what we have in common, and a growing concern about what some other actors in the world are doing. I mean, they really are operating in many ways, in many countries, with absolutely, unrestricted, unfettered access to personal data. And I think it's in our common interest to really work together to address that. That's not to say that we don't have to deal with, the issues in Schrems 2 or maybe other cleavages or differences that we have. We do, and we've done that in the past. We've come up with innovative solutions, as we did with Safe Harbor, to bridge our differences, and Privacy Shield. And I'm confident that we'll be able to do that again. So I'm sorry I wasn't able to speak more in a more detailed fashion on the redress question, but I think since the negotiations are ongoing, I need to be pretty discreet in terms of getting into too much detail.
Thank you. Well, we understand. And I think it's interesting what you say around privacy in the US and surveillance laws. And I think that's also what you see reading the white paper, is that many are information available aspects of and limits are in access by authorities to the data, to data that may not have been taken into account in 2016, because of course everything is evolving, and when the Privacy Shield was adopted, and maybe the question is more a question of transparency, or even, I would say, of complexity. I think when a legal regime is so complex, how can you convey to others what are the protections and what are the means for individuals to be protected? And I think that question will not be limited to the US, because we all know that with the Brexit, we will maybe have the same or the same question arising if the UK is becoming a third country and we need to find ways to transfer data to the UK. Then companies will have to look at their surveillance laws as well. And I was wondering if Bruno, you have any information for us, and I know that we are in the current negotiations of around Brexit, and that you might not be able to tell us a lot around that, but can you maybe update us or tell us more around what companies have to do, or for the time being, around their transfers to the UK, and maybe because everyone is wondering whether an adequacy decision will be possible, and that's an open question.
Can you hear me?
Yeah.
Can you hear me now? Yes.
Yeah, perfect.
I share certainly Jim's call for this question on our discussions. Of course, redress is clearly a key point if we want to fulfill the court requirements. And I would say this question is even more needed in this very delicate and complex phases of the overall negotiation with the UK. So it's this question plus, if I may say. But let me say 2 or 3 things, including on the UK. Number one, what Jim and I are doing, it's not a beauty contest. It's not about which system is better. we're not interested in that. I mean, it might be interesting for academic discussions. And I'm very, in a sense, relaxed in saying that, because as you know, the Commission, of course, defended its decision and defended the privacy shield and lost before the court. It happens. We were talking about the rule of law. So it's not about a beauty contest. It's not about relitigating the Schrems II case. It's about looking ahead and finding solutions. That's what we are interested in. Let me also say, because I know there's sometimes misunderstanding, that of course the principles, the rules, the requirements we are looking at in terms of necessity, proportionality, what has been mentioned in Redress, apply across the board, apply to transfers as they apply to EU institutions, as they apply to member states. Measures and laws, we had a confirmation of that a few months ago with a number of very important judgments, La Quadrature du Net, Privacy International, around the issue of, in particular, data retention. Or access to also bulk access to communication data. And the other thing I would say is the debate on the federal law in the US. This is not about, you know, having or not the secret recipe. I think that the fact that there is a debate on a federal legislation, omnibus legislation in the US on both sides of the aisle, by the way, is a sign of what we were talking about before, and what was also James recalling very well, that, you know, we are like-minded countries and we are facing and addressing very similar issues. When I see, for instance, I looked at the US discussion, US debate about, you know, for instance, the relationship with China and how data and privacy of certain particular sensitive data might have a relevance there too. It simply shows that we are facing the same challenges, while we're also trying to seize the opportunities of the digital economy, and that is reflected more and more in the development of either convergent solutions or at least similar debates. And I think that's very, very, very promising. We certainly believe that, and that's something, for instance, that we have clearly expressed in supporting the Japanese initiative around data free flow with trust, that, you know, if we have to think who has to contribute and develop international standards in the area of privacy, it's probably much better that like-minded countries such as Japan, the US, us and others do it rather than others. So I think that's and that's a fundamental shift, I think, compared to where the privacy debate, including the transatlantic privacy debate, was only a few years ago. And then the UK. Well, I can only confirm that we are intensively working on the adequacy decision concerning the UK. And I can say on the UK what I've said about we hope the next transatlantic arrangement. It needs to be something that can deliver the legal certainty you are expecting, and therefore to be solid decisions, including, of course, on these delicate issues we've just discussed. The Schrems II requirements also apply, of course, to the assessment of to the adequacy assessment concerning to the UK. This is just also to be very clear. This is a separate track from the negotiations on a possible future partnerships that are today in a I would say particular delicate, uncertain phase. So those are two different things. The adequacy track, both for the UK and for us, is autonomous from the trade, security, etc. Negotiations. But we of course understand the importance of data flows when it comes also to the UK in terms of trade, in terms of security cooperation, and that's why we are so much working as we speak on these adequacy decisions.
Yeah, thank you so much. Maybe to wrap up, what I would like to do is ask each of you. We have seen our 2020 being a really challenging year with many from a privacy and data protection side. And I would like to ask you, what are your expectations? What are the challenges you see for, and maybe the good news you see for 2021, so for next year? So I don't know who would like to start with this, but I would like to have your views and our positive mindset for 2021.
Maybe Elizabeth, I could just say a few things, and then I'd love to hear from the rest of the panelists. I think on your first question, the challenges, I think many of us have noted, with the pandemic, you've seen this dramatic uptick in reliance on digital technologies. And obviously with that comes just increasing reliance on cross-border data flows. I do want to make clear that at the same time, there is a countervailing concern about privacy. I mean, it is important in the pandemic context that, as we've seen the growth in the reliance on digital technologies and just how important it is for our economies and for governments, et cetera, and for our citizens, we need to make sure that we're addressing and monitoring, the privacy implications of that situation as well. I think that'll be an ongoing challenge for us. It goes without saying that Bruno and I and others are certainly working on the challenges generated by Schrems 2, specifically on Privacy Shield, but the broader issues, and as was noted earlier, there are global implications to the decision that impact the United States, the EU, but also many, many others. On the bright side, I will note that, I think one of the, I hesitate to call it an ancillary benefit because I do think it's a key benefit, but as I noted earlier, with the Privacy Shield situation and our annual reviews and our regular, frequent, ongoing dialogue in between those reviews, those really afforded some very positive and constructive opportunities for dialogue and harmonization and greater understanding and, growing coordination on these issues. I think the more we're talking, the more we're understanding one another's positions, the more we can realize that some of the differences perhaps aren't as significant as we otherwise might think they are, the better. And we have developed, as I noted before, we've been very creative in coming up with innovative solutions to bridge our differences. And I think that's a bright spot. I'm sure we'll do it again. And as Bruno and I and others have spoken to already, Bruno mentioned the OECD. I think there is now a much more robust discussion around these issues beyond just the United States and Europe. Bruno and I have both been at the table with our Japanese allies and the so-called trilateral discussions about what we can do together to address a lot of these issues. And again, I think there's common cause to be had around some of the practices we see with other countries that really don't give any regard to individual privacy or data protection. And so I guess I'll stop there. I think there are some challenges. I don't think they're insurmountable, but I am heartened again by what the Commission proposed last week. Obviously, I think Bruno's team and my team continue to have intensifying discussions and negotiations around the Schrems situation, and I've been very pleased and encouraged by the progress we've made to date, particularly since August. So I think there's a lot to be hopeful for.
Thank you. Maybe Ivana, may I turn to you for your prediction for 2021?
Oh, that's rough, I think, for 2021, if 2020 has taught us something in that regard. I guess more an appeal rather than a prediction. I think it was said many times today that we need to think globally. We need to think about what the impact of these, the decisions or the signals that sends internationally. And sometimes that means taking the road less traveled, the more difficult option in order to get the strongest fundamental rights protection possible. And also just maybe, a reflection as well. I was very happy to see Bruno mentioning the rule of law, absolutely right. But the rule of law has come under unprecedented stress in a way, both in certain EU member states and in the United States. So we're not operating in a vacuum, and we need to be aware of that as well, that, that the delicacy of some of these things that underpin our rights and democracy in that sense as well. And we will have at CDT, we'll be hosting actually an event in January where we'll look at this Schrems 2 again. So let's see how far things have progressed by January in that regard. And just very happy to
Thank
join
you
the
so much.
discussion
And
today.
I'll turn to Thomas and then leave Bruno the last word. So Thomas, what is your, not of your prediction, what do you want to say?
Thank you. No prediction. I mean, I don't want to focus on the challenges. I want to focus on the opportunities. I think what we heard today. There's a lot of willingness. There's a lot of like-mindedness to move forward to try and find first stopgap, short-term solutions, but also longer-term solutions. And I think that's what I want to focus on. I think there's a lot of willingness, both from government side, U.S. government, Commission, others. Japan was mentioned. Obviously, there's other partners around the world that are like-minded. We're seeing a lot of convergence on privacy laws around the world. This is great. This needs to continue, and this will continue. And and there's a lot more voices from the industry who also start to really engage. It used to be a technology sector issue. Now every sector is calling up, trying to find ways to ensure that we have privacy and data flows. They are both essential elements of moving forward. And so, as I said, I'm an optimistic person, and I know that we will find solutions. And 2021, bears a lot of promises on how we can recreate a real, certainty and way forward for
Thank you.
data
Thank
flow
you so
and
much.
privacy globally.
And Bruno, the last word is for you on 21. But you're on mute.
Yes, thanks for this opportunity to be the last, because it's easy to be the last when you agree with everything that your co-panelists have said, and which is absolutely the case. It's a challenge and an opportunity at the same time. Our approach on privacy as data flows is to be both assertive, because as it has been stressed, this is about values, this is about rights. For us, this is about fundamental rights. This is about common values, including, of course, with our American friends, and assertive and open. Find a way to, this is not about finding identical ways, but find the ways to build the bridge, which foundation have to be sufficiently similar. So it might be sometimes legally complex, might require some great engineering, but I believe that indeed, as I was saying, there's much more common grounds, not only between the EU and the US, but also at global level. Because, and that will be my last word on this, this is a global and a multi-actor conversation, to echo what Thomas has said. Yes, there are things that only government can deal with, but there are also a lot of input, ideas, best practices that can come from the business community, from civil society, because indeed we are dealing with privacy, but as we just discussed, we are dealing with, in a certain sense, much more than privacy. Rights are not isolated, don't work in a vacuum. You cannot isolate one right. So I was actually very encouraged myself by what I've heard today, and now we have to go back to work and work and work and work.
Thank you.
So thank you very much.
Thank you so much to all of you for this very, very insightful panel. Thank you.
Thank you, Elizabeth.
Thank you.